and that was not what the motion on Monday night said. This decision requires much more deliberation and research before that vote was taken. The OMB decision was only days old. It is a document that was not what the motion on Monday night said. This decision requires much more deliberation and research before that vote was taken. The OMB decision was only days old. It is a document that demands close inspection on exactly what it meant, including the part that this council could exercise its own legislative powers and was not fettered by prior council's decision. This past council that I sat on did just that. They overturned the decision of the prior council to them, which was to develop the north side of the road. This past council chose to ignore that, seek out a private-public partnership on the south side, and use the $70,000 that was set aside by the prior council, earmarked for capital improvements at Bay Beach, to fund the study and moving forward on the public-private partnership. It was used, that's the dollars, that's where they got the dollars. I hope this council will take a step back. I hope they will get an outside opinion regarding their options, a legal opinion from someone who will look at these agreements, the memorandum of understanding, with fresh eyes, and lay out possible options and alternatives and consequences. Only then should this council decide whether we should proceed with this development. Thank you.
Are there any comments, questions, Councillor Sneckman?
Thank you, Mayor Martin, through you to the delegation. Ms. Noyes, thank you for your presentation tonight. You touched on the fact that during construction the bathrooms possibly would be removed, or we wouldn't have bathrooms for the duration of the construction. And I know that you're aware that the bathrooms are one of the community benefits that the town is receiving in exchange for the property. What about the other community benefits that are in the agreement? What are your thoughts on those?
Well, again, being on the past 3-4 councils, and the recent community benefits that were outlined, I think by Mr. Tripp, if I'm not mistaken, is that a lot of those benefits I don't think are community benefits. I think that any developer in any other situation would be compelled to provide the community benefits, like the road improvements, the water and sewer improvements, all those things they would have been compelled to do it just as a matter of course that other developments have. I can't tell you the number of times we've had developers coming before us who are building a townhouse or building 3 or 4 other buildings, and were forced to improve the roads, improve the water and sewer at their cost. I think they do half the road, and the town accepts half. The things like the the break wall and all those kind of things. Again, any developer, this was happening a mile down the road on private property, that entire cost would have been borne by the developer. In this case, we're calling it a community benefit. In my, like I'm going to talk about the bathrooms a bit, is that we're going to have 2 bathrooms underneath the Lobster House, and who knows if they're going to be viable over the long run. And we're going to have vending machines, is what I understand, in regards to servicing the public. The Civic Center, in my opinion, is terribly expensive, and I think it's going to be primarily used by the condo themselves as their common room. I don't know that for a fact, but I mean, I'm anticipating that, since there doesn't appear to be any common room building in that building other than the Civic Center. And I understand, in discussing it with staff prior, that they would be entitled to rent this out just like anyone else would be. The costs, I think, I don't know where the costs came from. I know Mr. Tripp was asked a few times how he came to the numbers he did. Never really did get a clear answer. I don't know whether the numbers are accurate or not. I can say in the past, there's several examples I can give if you want them, where the staff, somewhat outside their skill set in regards to estimating building costs, came up and they were very low, and the cost for the development or the buildings and the improvements came in much higher than they were anticipated.
Thank you.
Thank you very much for your delegation, and welcome back to the chambers. Just a question. You had indicated in your remarks that the past terms council had overturned a decision that, or a direction, I guess, that the previous council would have made, and I'm saying that that would have been the Mayor Ridicop's council. Am I correct in thinking that?
Yes.
Okay. At what point during the term did that decision get overturned? And if you can, just elaborate a little bit more on the circumstances with regards to that decision.
All right. And again, this is when you're here for 13 years, some of the years just kind of roll into the others. So don't think this is Bible if I say 1 year it was the next. It was the last year of, I guess, a year and a half before Wayne Redicop's last tenure that we came to the decision on the north side of the road, and I think it was the northeast corner, that we want to do a private-public partnership there and keep the south side for the beachgoers. And we had made some steps in regards to looking at the Lobster House, and was it a viable option to kind of rejig it, so to speak. And we came to the point that if we made it a shell and we improved the plumbing, the hydrant, all those kind of things, we could probably find some renters for it and address the amenity needs of the residents. Now, in regards to the new council came in. I think it was the second year, if I'm not mistaken, it was the second budget, during a budget meeting, that Councillor Lockwood brought up the idea of moving forward with investigating the south side of Erie Road for a public-private partnership. Not sure where that idea came from, and the $70,000 that was earmarked for capital improvements on a building at Bay Beach was then going to be moved from that towards the dollars that were needed to pursue to look into the private-public partnership. And that was, I think, the second budget year.
Anything further from anyone? Seeing none, thank you. Mr. Bob Lund, the Crystal Beach Gateway Project. Mr. Lund. And Ms. Noyes, if you could leave a copy of your presentation with the clerk, I'd appreciate it. And same with you, Mr. Lund, if you could leave a copy.
Yes. I'm not I distributed copies to all I'm not sure whether I gave one to you. If I didn't, I have one right here. I would like to give it to you now, and I can also give you one afterwards, all right? You've got one already in there. Good luck. I have two more. All right? I have two more. Do you want it now or after? Okay. Mayor Martin, councilors, Fort Erie, staff, and ladies and gentlemen, I thank you very much for hearing me out tonight. I'm here to talk about the OMB decision and how it pertains to the Gateway project, some things it mentions and things that are not particularly taken or talked about. There are 4 basic points regarding the decision of the OMB. 1, the OMB hearing officer made it clear in his decision that the new council is not bound to support the previous council's decision on the zoning bylaw 26-10. The hearing officer specifically said that the new council can exercise its full authority and is not fettered by the previous council's decision. Everything you need to know about this is on pages 2-4 of the OMB decision. I have included that in your in the packet that I gave you, and I would like to just read a couple of lines from that at this particular point. Down on page 2, I have highlighted that, and it says, while the current November 2010 Town Council entered into a partnership with the Molinaro Group to develop a portion of the Bay Beach property, the board heard that as a result of the October 25th, 2010 municipal elections, 1 incumbent town councilor and 3 new councilors, representing 4 of the 7 possible council votes, have expressed their views that they do not support the proposed zoning bylaw amendment 2610, or as it's known, ZBA 2610, in its current form, by way of the notice of motion and their sworn affidavits. Mr. Gillespie advised the board that these councilors intend to make one or more revisions to the ZBA 2610 and to express their opposition to the development proceeding as agreed to by the current council. All right, also, further on down, there exists a series of procedural and process mechanisms available to the new town council to respond to any determination of this matter by the board. Further, the Planning Act will afford the new council a number of ways to respond to the board's order. And the board determines the council's legislative power would not be fettered by this matter proceeding on November 1, 2010. A new council is not bound to support ZBA 26-10. And one other thing on page 3, in any event, the new council is free and able to exercise its full authority. This is a decision of the OMB. So they're saying that they're going to come up with a decision. That decision is on the legality. And as I stated my first, on number 1, on page 1, the hearing officer specifically said that that can exercise its authority and not be fettered by previous. Everything you need to know about this, all right. The rest of the 54 pages, is number 2, decision summarizes why the hearing officer concluded that the previous council didn't do anything illegal in passing bylaw 2610, and that's right. In other words, they crossed the T's right, they dotted the I's right, and that's all he was to judge. He didn't tell you or anyone else here that you couldn't change that bylaw or amend it. Number 3, the purchase and sale agreement that the council approved last June is a contingent contract and will not be a legally binding contract until all 5 conditions listed on section 4 are met. And I have an attachment there. It's in your packet. In fact, the town still owns the property until all the conditions are met. And if I might go to that, let me just get this out here. It says at the top of the page, it's 3 of 13, conditions for the benefit of the buyer and the town. The completion of this transaction is conditional upon 1, the final disposition of the zoning bylaw, number 2610, or on or before December 31st, 2012, failing which the agreement shall be at an end, or in the event that the final disposition results in substantial modifications or amendments to the bylaw, any party who determines that the final disposition is unacceptable shall have 10 days from the date of the final disposition to deliver to the other party a notice terminating this agreement, failing which the final disposition shall be deemed to be acceptable such party. And number 3, issuance of a permit from the Ministry of Natural Resources pursuant to Section 17 of the Endangered Species Act, such and such 2007, with conditions acceptable to the parties on or before December 31st, 2012, failing which the agreement shall be at an end. Number 4, any party who determines that the conditions with respect to the M&R permit are unacceptable shall have 10 days from the date of the issuance of the M&R permit to deliver to the other party a notice terminating this agreement, failing which the M&R permit shall be deemed to be acceptable to such party. Lastly, number 5, the buyer and the town entering into an agreement pursuant to Section 37 of the Planning Act, which shall be held in escrow point by the town pending the transfer of the property to the buyer, failing which this agreement shall be at an end. So there's lots of leeway there for you. And you should not be intimidated by arguments. And the last thing on my page, number 4 of the 4 points, it is simply not true that the town will face millions of dollars in lawsuits if the council amends or repeals the bylaw soon. If the council does it before the deed changes hands, the costs are unlikely to be high because of the conditions of the contract have not yet been met. Molinaro knew he was taking a big risk when he got into this deal. He knew all these conditions had to be met, and he knew a newly elected council might decide to change the bylaw. Molinaro may very well sue the town if the council changes the bylaw, but he won't have a strong case. Repealing the law would definitely be the least costly decision the council can make. Now, I was in business, and I'm going to give you this example. I had salesmen on the road. I paid their expenses. I paid their salary. I paid for equipment. I paid for an establishment, office equipment, and so on. When they went out and quoted a job and we had to make presentations, sometimes we had to have 2 or 3 people.